Hello friends, welcome to Bilateral Legal Arrangements series guiding Nepal's foreign relations. On this episode, I'm presenting the agreement and protocol on transit between government of Nepal and the government of the People's Republic of China. So let's begin with the agreement of transit transport between the government of Nepal and the government of People's Republic of China. The government of Nepal and the government of the People's Republic of China, the contracting parties, with the desire to maintain, develop, and strengthen the existing friendly relations and cooperation between the two countries, noting the relevant international legal instruments, especially the 1982 United Nations Convention on the Law of the Sea, recognizing that Nepal as a landlocked country has the right to have permanent access to and from the sea and the right of freedom of transit, and realizing the need to facilitate the transit transport through their territories, considering the importance of the One Belt, One Road initiative proposed by the government of the People's Republic of China, have agreed as follows. Article 1. The contracting parties shall provide each other with the freedom of transit across their respective territories through routes mutually agreed upon, operational modalities including the utilization of ports, routes, conditions of transit, mode of transport and transfer of goods, costumes, and other necessary arrangements to facilitate transit transport shall be mutually agreed upon by competent authorities of the contracting parties and shall be laid down in the protocol, which shall be an integral part of this agreement. Article 2. 1. Each contracting party shall have the right to take all indispensable measures to ensure that transit activities on its territories does not in any way infringe its legitimate interests of any kind or facilitate any transnational crimes such as stop, stowaways, money laundering, and arms smuggling. 2. Nothing in this agreement shall prevent either contracting party from taking any measures which may be necessary for the protection of its essential security interests. 3. While protecting legitimate interests under this article, the contracting parties shall adopt least transit and trade restrictive measures. Article 3. 1. The term transit transport means traffic in transit, which covers the passage of goods, including consigned baggage, across the territory, including territorial land, inland waters, and territorial seas of a contracting party, when the passage is a portion of a complete journey which begins to terminate within the territory of the other contracting party, with or without transshipment, warehousing, assembly, disassembly, or change in the mode of transport. Nothing in this article shall be construed as imposing an obligation on either contracting party to establish or permit the establishment of permanent facilities on its territory for such assembly, disassembly, or reassembly. 2. The contracting parties agree to use railway rolling stock and road vehicles, vessels, and other transport means agreed upon by the contracting parties in transit transport. Article 4. The cargo and goods in transit transport shall be exempt from customs duties and from all transit duties or deposits for the payments of these taxes of transit state, if the customs and the relevant quarantine and inspection departments of the contracting parties are satisfied that the requirements for transit transport procedures are met, except reasonable charges for transportation and such other charges as are commensurate with the costs of services rendered in respect of such transit transport. Article 5. For convenience of the transit transport, the contracting parties agree to provide at point or points of entry or exit on such terms as may be mutually agreed upon by competent authorities and subject to the relevant laws and regulations prevailing in either country, warehouses or sheds for the storage of transit goods awaiting customs clearance before onward transmission. Article 6. Transport shall be subject to the procedures to be mutually agreed upon by competent authorities and subject to relevant laws and regulations prevailing in either country, as well as international treaties to which the contracting parties are signatories, except in cases of failure to comply with the procedures prescribed. All appropriate measures shall be taken by either contracting party to rule out avoidable delays or restrictions in such transit. Such procedures may be laid down in a protocol agreed upon by competent authorities of both sides. Article 7. In order to enjoy the freedom of high seas, merchant ships sailing under the flag of Nepal shall be accorded, subject to the laws of the People's Republic of China, treatment no less favorable than that accorded to ships from any other foreign country in respect of matters relating to navigation, entry into and departure from the ports of China, use of these ports and harbor facilities, except that the provisions of this article shall not be extended to the coastal trade. Article 8. Notwithstanding the foregoing provisions, either contracting party may maintain or introduce such measures or restrictions as are necessary for the purpose of protecting public moral, protecting human, animal, and plant life, health, and security, safeguarding implementation of laws relating to the import and export of gold and silver, safeguarding state security and political, economic, and social stability, preventing the smuggling of goods and safeguarding such other interests as may be mutually agreed upon. Article 9. Nothing in this agreement shall prevent either contracting party from taking any measures which may be necessary in pursuance of general international conventions, whether the contracting party has signed or will sign hereafter, relating to transit, transport, export, or import of particular kinds of articles such as narcotics and psychotropic substances, animal and plant quarantine objects, or in pursuance of general international conventions intended to prevent infringement of copyright or trademark right, or relating to false marks, counterfeits, or other methods of unfair competitions. Article 10. 1. In order to facilitate effective and smooth implementation of this agreement, the contracting parties shall consult each other when necessary. This agreement may be amended upon consensus reached by the contracting parties through consultation. 2. The modalities, routes, condition of transit, costumes, and other necessary arrangements may be reviewed and modified by the contracting parties to further facilitate transit transport. Article 11. Any dispute or difference which may arise in the application or interpretation of this agreement shall be settled through consultation between the contracting parties. Article 12. This agreement shall come into force on the date of signature, remain valid for a period of 10 years, and be automatically renewed in every 10 years unless either of the contracting party gives to the other a written notice 6 months in advance of its intention to terminate the agreement. Done in Beijing on March 21st, 2016 in duplicate in the Nepalese, English, and Chinese languages, all texts being equally authentic. In case of divergence, the English text shall prevail. Signed for the government of Nepal and for the government of the Republic of China. So this was the transit agreement between Nepal and China done in 2016. So now let's begin the protocol between the government of Nepal and the government of the People's Republic of China on implementing the foregone agreement on the transit transport between the government of Nepal and the government of the People's Republic of China. The government of Nepal and the government of the People's Republic of China, PR China, hereinafter to as the contracting parties desiring to implement the agreement on transit transport between the government of Nepal and the government of the People's Republic of China, hereinafter referred to as the agreement signed on 21st March 2016 to develop transport between the two countries, have agreed as follows. Article 1. Definition. In this protocol, 1. Means of transport refers to railway vehicles, road transport vehicles, ships, vessels, and other means of transport agreed by the contracting parties. 2. Competent authority refers to A. Ministry of Transport on the part of the People's Republic of China. B. Ministry of Industry, Commerce and Supplies on the part of Nepal. Article 2. Ports and routes. 1. The People's Republic of China allows Nepal to use open sea ports for handling its traffic in transit. The list of the sea ports to be used by Nepal is attached in Appendix 1st, which may be reviewed by the joint consultation mechanism referred to in Article 14 of this protocol. 2. The People's Republic of China allows Nepal to use open dry ports for handling traffic in transit. The list of dry ports to be used by Nepal is attached in Appendix 2nd, which may be reviewed by the joint consultation referred to in Article 14 of this protocol. 3. The border ports between Nepal and China for transit transport are attached in Appendix 3. 4. The PR China allows the movement of vehicles registered in Nepal which hold the permits issued as per Article 6 of this protocol to transport transit cargo between Nepal border points and Rikaze dry port. 5. The transit routes to be provided to China by Nepal are to be decided through future consultation between the two sides upon adequate development of transport infrastructure in Nepal. Article 3. Means of transport. The means of transport for the movement of traffic in transit by road as defined in paragraph 1st of Article 1 of this protocol shall meet the conditions required by the competent authorities and hold the permits issued as per Article 6 of this protocol. Article 4. Facilities. The provision of transit facilities shall be in accordance with applicable international instruments, costumes, and agreements. Facilities for traffic in transit shall include railways, channels, berthing facilities, and docks for cargo ships, multimodal transport or transshipment, terminal handling equipment, warehouses or sheds for storage of transit goods awaiting customs clearance before onward transmission. Article 5. Contraband. The contraband items prohibited from transportation by either party shall not be allowed in traffic in transit. Article 6. Road transit transport. 1. Paragraph 1. Transit transport operators shall be any natural or legal person registered in the territory of either contracting party having acquired transit transport in the territory of such contracting party. 2. The number of transit transport permits required for a year shall be determined by the competent authorities as per the need of the relevant contracting party through consultation every year. The permits shall be exchanged between the two competent authorities and delivered to the transport operators by the competent authorities of the contracting party or by a body designated by such competent authority. 3. The permits issued under this protocol shall be used and remain valid for one entry-exit journey unless otherwise stated in the permit. The permit shall be valid from issue until 31st January of the successive calendar year. 4. Transit transport permits are owned by the transit transport operators for which the permits are issued. The permits shall not be used by and are not transferable to other transport operators. 5. Cabotage is forbidden in the territory of the relevant contracting party other than those services, facilities, condition and modalities specified in this cabotage. 6. Vehicles used for transit transport shall meet the applicable national standards of the relevant contracting party with respect to safety and environment and the customs regulatory requirements. Vehicles for international transport operations shall have the license plates, nationality identification marks, and safety technology verification signs or certificates registered in their respective countries. 7. The permissible maximum weight, axle, weight and dimension of vehicles must not exceed those stated in the relevant legal provisions and technical standards of the relevant contracting party. In case of exceeding the permissible limit in terms of weight and dimension due to the indivisibility of the load, an authorization is required from the competent authority of the relevant contracting party beforehand. And then 8. Transit transport operators of relevant contracting party transporting dangerous goods shall obtain special permits issued by the competent authority of the other contracting party, and the routes must be specified in the permits. Vehicles carrying dangerous goods must be equipped in accordance with the requirements of the national legislations or applicable international conventions and are required to be labeled with dangerous goods placards and marks. 9. Drivers engaged in transit transport operations shall possess a valid driving license in accordance with the vehicle category and vehicle registration certificate, and their translated documents specified in this protocol shall be kept in the vehicle and be produced in demand by the competent authority of either contracting party. Article 7. Other modes of transit transport. Transit transport operators from one contracting party may use railways, ports, inland waterways, and other modes of transport in the territory of the other contracting party to carry out the movement of transit transport. Such transit transport shall be in accordance with the laws and regulations of the relevant contracting parties. Article 8. Costs and fees. The cargo and goods in transit transport shall be exempted from customs duties and from all transit duties or deposits for the payments of these taxes of transit state if the customs and the relevant quarantine and inspection departments of the contracting parties are satisfied that the requirements for transit transport procedures are met, except reasonable charges for transportation and such other charges as are commensurate with the costs of services rendered in respect of such transit transport. Article 9. Transit transport procedures. Transit transport operators shall follow the transit transport procedures of the customs agency of the contracting party in regard to submitting or transmitting of all necessary transit documents, including cargo lists, information data of transport means prior to arrival of the cargo. Article 10. Facilitation. 1. Facilitation for traffic in transit shall be extended between authorities of the contracting parties according to the laws and regulations of the applicable international instruments. 2. Priority shall be given to traffic in transit containing animal and perishable goods in extending facilitation by border security, customs, transport administration, and sanitary agencies upon application. Article 11. Treatment to traffic in transit. 1. No discrimination shall be made to traffic in transit of the relevant contracting party by any mode of transport on the basis of flag of vessel, ownership of goods, ownership of vessel, place of origin, departure, entry, exit or destination, or any other ground. 2. Exemption of technical standards and conformity assessment for traffic in transit shall be in accordance with laws and regulations of the relevant contracting party in conformity with the applicable and international instruments. Article 12. Application of law. Transit transport operators shall abide by traffic rules, compulsory insurance for traffic accident, and other laws and regulations of the relevant contracting party, and comply with applicable international instruments and other bilateral and multilateral agreement to which both contracting parties are party to. In the event of traffic accident involving a transport vehicle registered in the states of both contracting parties, it shall be dealt in accordance with the relevant provisions of the country in which the accident occurred, and the competent authorities of the other party shall assist in providing the necessary information for the investigation of the cause of the accident. Article 13. Punishment and notification. Transit transport operators of one operator of one contracting party violating the transit transport related laws and regulations of the other contracting party shall be liable to punishment as per the laws of the contracting party where the action occurred. In such case, the contracting party shall notify the action taken to the other contracting party. Article 14. Joint consultation mechanism. Article 14. Joint consultation mechanism. 1. A joint consultation mechanism (JCM) at the level of Vice Minister in the Ministry of Transport of the People's Republic of China and the Secretary at the Ministry of Industry, Commerce and Supplies of the Government of Nepal shall be established to review the implementation status of the agreement and this protocol, to discuss and resolve the issues forwarded by the Joint Consultative Subcommittee (JCSC) specified in paragraph 2 of this article, to mandate JCSC to work out on particular technical matter and to conduct negotiations on other issues pertaining to the agreement and this protocol. Paragraph 2. The JSCS shall be constituted at the level of Joint Secretary or Director General of the aforesaid ministries of the two governments, with members from relevant ministries, agencies dealing with foreign affairs, customs, public security, home affairs, transport, quarantine, and so on. A local level mechanism shall be formed under the JCSC to deal with day-to-day issues regarding the implementation of this protocol. 3. The JCSC shall review modalities, routes, conditions of transit, costumes, and other necessary arrangements, conduct technical consultations, discuss transit transport related issues, and recommend to the JCM for modifications and revisions of the agreement and this protocol with a view to further facilitating transit transport. 4. The JCM and JCSC shall meet at least once a year or as deemed necessary, alternatively in Nepal and the People's Republic of China. The JCSC shall schedule such meeting at least 3 months before the JCM meeting. Article 15. Entry into force and duration of the protocol. 1. This protocol shall enter into force on the first day of the next month following the day of the receipt of the letter notification in writing through diplomatic channel, by which the contracting parties shall notify each other on the completion of internal procedures necessary for entry into force of this protocol. 2. This protocol shall remain valid in accordance with the validity of the agreement. 3. This protocol does not affect the rights and obligations arising from the other international instruments to the contracting parties. 4. Done at Beijing on 29 April 2019 in Nepali, English, and Chinese, each text being equally authentic. In case of any divergence in interpretation, the English version shall prevail. Signed by Government of Nepal and the Government of the People's Republic of China. The Appendix First of this protocol states the list of seaports in China to be used by Nepal is as follows: Tianjin, Shenzhen, Lianyungang, Zhanjiang. Then Appendix 2, the list of dry ports in China to be used by Nepal for traffic in transit is as follows: Lanzhou, Lhasa, and Rikaze. Appendix 3. So border points are Rosua Zilong, Kodari Zhangmo, Kimathangka Chentang, Nechung Lizi, Ari Pulan, Olangchungola, and Riu. Chetang, Lizi, and Riu shall be used after formal opening. So these were the appendix of the protocol. So this is the end of the Nepal-China transit protocol. So this is all about this episode. In this episode, I presented the transit agreement between China and Nepal and related protocol. So please do like, share, and subscribe this channel for regular legal updates like this. And this is all for today. Goodbye.